Do you know such oil and gas terms as pooling, capture, delay rental, royalty, and shut-in? I'm Dan Ringer, and we'll talk about oil and gas leases right now on the Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
How can you decide whether you want to sign that oil and gas lease you've been given? The best way is to understand it. My guests are attorneys Andrew Graham and Kenneth Tawney. Andy, Ken, thanks for joining us again.
Well, thanks for having
us back, Dan.
Well, this topic, we want to talk about oil and gas leases, and I got to tell you, it's formidable. There is so much to these things and so many different possible combinations of circumstances, but I just want to take a run at it. So would somebody please tell me basically what an oil and gas lease is?
Well, there, I guess, are two ways that you can look at it, or you can say that an oil and gas lease has two kinds of characteristics to it. One is that it is like a deed. It conveys an interest in real estate because it says that the interest that the mineral owner, the owner of the oil and gas has, is now going to be given to the developer, the driller, to drill for oil and gas, and as the terms of that property arrangement that the oil and gas owner will get money for it. It's also like a contract because it's the relationship between these two parties in terms of certain kinds of rights and obligations that they owe to each other, that the oil and gas owner will grant certain rights to the oil and gas driller, and in return the driller is making certain promises back to the owner in terms of how they'll be paid, how they'll conduct the drilling operations, that sort of thing.
When we talk about an interest in real estate, there are all kinds of interests, and listening to you define what this oil and gas lease is, it's really no different from any other agreement concerning the usage of real estate. If I want to rent an apartment, I'm getting the right to enjoy the apartment subject to some terms and conditions, and I agree to do certain things, basically pay the rent and not to destroy the place, and the landlord agrees to do certain things, make sure that it's there, and basically leave me alone while I'm doing it. The problem with oil and gas leases is the devil's in the details.
Well, it's that way with any...
In its simplest terms, Dan, it is merely a contract between the two parties. And it gives the lessee, or the operator, the driller, the right to explore for and to produce natural gas or oil if they find it in the drilling process. It generally has what's called a primary term, and it will be for a period of years. Usually a 5-year term is fairly standard, and it gives the right to the operator to drill during that 5-year period. If they do drill and they find oil and gas, then the lease extends throughout the period during which the oil and gas is produced. So it could extend for several years. There are still perfectly good leases that were signed back in the 1800s that are still in existence today.
And you saw a development through time as oil and gas leases or oil and gas development first started. No one knew how long these wells would last, and so there was really just the primary term. And then as people began to figure out that, well, if we drill the well, it could last for 5 years or it could last for 105 years, we'd rather just have the right to keep producing the gas and paying the mineral owner so long as the well is producing, that became the fairly standard language. And then, you're talking about the complications in the leases. It's because this business has been around for 150, 160 years, as time goes on and new circumstances are encountered, it's like, well, we should put that into the lease. And so you begin to get things like the shut-in royalty clause and various kinds of maintenance provisions in there that say that, well, if we only have one well on your property and we have to stop producing to fix it, we don't want to lose the lease, so we're going to put that as a separate clause in here that says that we have the right to fix that well, and we'll pay you a little bit of money while we're doing it, and then we'll go back to producing as if we'd never stopped producing at all.
There is an old saying at the Department of State in the military about combat, and that old saying is, you're always preparing to fight the last war, because you learned lessons from the last war, so now you're going to get ready to fight it again, only the next war is going to be substantially, if not completely different. And the same sort of thing happens not only with oil and gas leases, but pretty much with any contract. You sit down and it's a game of what if, and if you can think of the right the right circumstances, you can provide for them. But if it's something nobody's ever seen before, what do you do? And that kind of comes around to Marcellus Shale. We were leasing oil and gas for years. We were selling coal, limestone, sandstone. And all of a sudden, here's a new form of gas, and coal bed methane a few years ago also. We have to now stop and reconsider everything. Or you have a technological development like horizontal drilling. Now we got to go back and rewrite everything to take account of these things.
It's not substantially different with the Marcellus Shale. Yes, there are different considerations in some respects, but the same basic elements are there. You're giving the operator the right to produce, to drill and produce, and that operator is paying royalties to the oil and gas owner. So there's some of the technological aspects of it change, but at the end of the day, it's still much the same as it was 100 years ago.
Well, let's talk about what the lessor, that is the person who wants to explore for oil and gas, can do.
Well, the lessor would be the oil and gas owner.
See, I get confused. The lessee is the one who wants to explore.
Right.
You sign this lease. What do you get for signing it?
Well, typically there will be what's known as a signing bonus, perhaps, or it can be done a couple of different ways. Historically, the way that the lease was set up, it would be for this, let's say, a 5-year primary term. And in the lease, it would say that the lessee would agree to pay rent, a delay rental of a certain amount of money, usually calculated on a per acres within the lease basis. It's become much more common now for the lessee to pay that money up front and say, we want a 5-year term, and so we're going to pay you the full 5 years worth of rent right now, and depending upon how valuable the property is in the lessee's development plan, there may be additional signing incentives, but the main money that comes when you sign the lease is the so-called rent, and then that will be converted to royalty when a well is drilled and begins to produce and the gas is sold from it, and that becomes the main money that comes to the lessor at that point in time.
So you're going to get a certain amount of money calculated, however it's calculated, whether it's on a per acre basis or per pound basis or whatever you do with it.
Right.
Pounds of what, I don't know.
I think the per acre basis would be by far and away the most typical way of saying, it used to be $1 an acre. Now it might be $1,000 an acre, or however much money the lessor can negotiate out of the lessee in terms of the value of the property.
But you get that up front.
Generally now, the practice has become to have what they call a paid-up lease. As he said, in the early days, the delay rental would be paid on a per acre basis each year. So if I did not drill a well in the first year, I would pay the next installment of delay rental in the second year and so forth until such time as I drilled a well. Here in the past few years, it's become more common for them to simply pay the full 5-year amount up front and have what they call a fully paid up lease.
Then the lessor, the owner of the interest, the original interest, wouldn't receive anything for the next however many years.
Until a well is actually drilled and put into production.
Or if a well isn't drilled and the 5 years runs out, then whenever the owner of the oil and gas signs a new lease, then that would become a whole new economic relationship, and so there might be money at that point in time.
And this 5 years is referred to as?
A primary term. It's the first term of the lease. And we think of like an apartment lease that might be for 12 months. Well, this is the lease of the term of an oil and gas lease is divided into two kinds. There's the primary, which, as Ken said, is usually a set period of time. 1 year, 12 months, 5 years, 10 years, whatever it may be. And then the so-called secondary term, which is that once we've drilled a well, the lease will continue to be in effect so long as we're producing oil and gas.
We're talking about oil and gas leases. My guests are attorneys Andrew Graham and Kenneth Tawney. I'm Dan Ringer, and this is The Law Works. Well, I've leased my oil and gas. Nice fellow came by, offered me a substantial amount of money, said it's cover the next 5 years. We're 4.5 years into it now, and nobody's drilled on my property, and they're telling me they're not going to drill on my property, but they're producing oil and gas from my property.
Aha.
How does that work?
Well, that would sound like that probably the lease that you signed contained a unitization clause or a unitization agreement, which says that one of the rights that you've given to the lessee is the right to combine your land with adjoining land to create what's known as a drilling unit. And if we think about the traditional method of drilling an oil and gas well was just to drill a hole from the surface to someplace down under the ground under one tract of land. As I think we talked last time about horizontal drilling, now you're drilling out under adjacent properties, and so you've got gas flowing to one hole, but lots of different tracts maybe are contributing that gas. So in order to operate a well in that manner, you need an agreement from all of the affected oil and gas owners to say that we're going to all agree we only need the one hole, but we're going to share in the money that comes from the gas that comes through the well that may be on my neighbor's property. Now, if your lease doesn't have that unitization clause, you may have an entirely different legal problem. But
I'm presuming that everybody's obeying the law and doing
right,
things
yes.
properly.
So, but that would, and that is one of the technological advancements in as far as horizontal drilling, which had not been used much in West Virginia until the Marcellus boom, has led to the need for oil and gas leases to have that language in there. You have to have an agreement, basically, with your oil and gas owner that you can do that. The traditional viewpoint was the lease was an agreement between one owner and one driller to drill a well on that owner's land, not to drill a well on the neighbor's land and then share the money. So that has to be part of the contract between the owner and the driller.
But that's kind of inherent, though, in producing oil and gas or water or any other liquid. If I have a bucket and Ken owns the left side of the bucket and I own the right side of the bucket, and they stick a hose in Ken's side, my side of the bucket's going to get emptied just as fast.
That's been recognized in the law as the rule of capture. And under current law in this and many other states, as long as I have a well drilled on my property, I can produce the gas or the water from that well, even though it may be draining your side of the bucket. And that is okay because I haven't drilled that well on your property.
What am I going to get because of the stuff that's coming out of my side?
You need to go have somebody come and drill a well on your property in order to capture your part of the water.
So I have to get my own hose.
You do. Now with horizontal drilling, what Andy was alluding to, the rule of capture still exists. Even with horizontal wells. But if that wellbore is drilled through neighboring tracts, you still have to have a lease from each of those landowners, and then you pool those leases together to form the drilling unit in order to drill that 4,500, 5,000 foot lateral. So basically, you need a tract of land a mile long in order to drill that one horizontal well.
And these are individual leases with the owners of the interest in which you're passing through.
That's right.
They might have different terms.
Yeah, and I think of pooling, I like the golf course analogy. If I'm a driller or an operator, I could have 18 different golf holes. And if I pool those 18 golf holes, now I can have a golf course. And so that is the same basic concept as pooling leases. I now have enough leases in a row here that I can drill this horizontal lateral out to about a mile.
And with horizontal drilling, you can drill many wells, many lines in different directions from one point.
Right.
That's correct. Generally, I think people are thinking that 6 to 8 horizontal wells from the same pad might be optimum, and so they can actually drill underneath the ground. And you think of a pitchfork with 3 or 4 prongs sticking out in one direction and 3 or 4 prongs on the other side. And in the Marcellus, they generally form their units on a northwest-southeast quadrant so that they can cross the natural fractures in the formation better, and so they can get a better result when they actually fracture the well. So by forming their units in that manner and pooling those leases, you get a better result.
So it sounds as though if someone comes to me and says, Dan, we'd like to negotiate an oil and gas lease with you, and I say, no, I don't want the oil and gas taken from under my property, that's not really my decision, is it? Because at least some of it is going to be taken, whether I agree to the lease or not, through this rule of capture, although no one will actually be doing any drilling on or under my property without my permission.
It's possible. Each well is going to have a drainage area, and so depending upon the nature of the well, it will drain a certain area, and so it's possible that the well could drain gas from an adjoining tract.
One of the interesting things about Marcellus Shale is the shale is so dense you wouldn't expect to drain a large tract with just a single hole next to a piece of property, because you have to get out under it. Mm-hmm. But if you're drilling through sandstone or taking gas or oil from sandstone or something else, it could drain quite a bit.
Yes.
Mm-hmm. We're talking about oil and gas leases. My guests are attorneys Andrew Graham and Kenneth Tawney. I'm Dan Ringer, and this is The Law Works. Let's talk about royalties. What is a royalty?
The royalty, at least in oil and gas terms, is the money interest that comes from selling the gas or oil, and for whatever reason, the money was divided up into eighths historically, and so typically the lessor, the owner of the oil and gas, would get 1/8 of the money that came from selling the oil or the natural gas, and then the driller would keep the remaining 7/8 of the money. Now those fractions have changed some over the last couple of years. Lessors have recognized that my acreage is very valuable to a drilling company, and so therefore I want more than 1/8 of the money. I want 15%. I want 20%. Some number higher than 12.5%, which was historically what lessors got. Actually, I guess I should say historically. You can find lots of old leases where you just got paid a certain flat rate for every well that was drilled on your property. You might get $200 or something like that, but the recognition by the legislature that wasn't really fair to gas owners changed the law in West Virginia in the late 70s, I think it was, that said that you have to pay a percentage, and that percentage historically has always been 12.5%. Now it's oftentimes more.
So,
But that's basically, when people say royalty, what they mean is money, and it's the money that's coming because of the contractual relationship in an oil and gas lease.
well, and that's one of the things that keeps changing is how that royalty is calculated. And we probably don't want to try to be specific about that because there's so many different things involved.
Well, Dan, and one thing I should probably mention is that gas prices have a significant impact upon what drillers are willing to pay in terms of royalty. And so back a couple of years ago, when natural gas prices were up and consistently up in the $7-8 a decatherm range, they were willing to pay higher royalties. But now with the Marcellus Shale boom, we're suddenly in a situation where we have a lot of gas on our hands, and simple law of supply and demand have caused the drillers to retrench because they're only making around $4. And gases have creeped up a little bit at near $5 here now the cold weather is hit. But they're able to sell the gas now for about half of what they did. And so the willingness to pay more than the traditional 1/8 is not there now.
The good news is we've got twice as much gas as we thought we had. The bad news is it's worth half as much.
Exactly.
So you come out just about
Exactly.
the same. What happens to the surface when somebody comes in and says, okay, I'll sell you my oil and gas, I'll lease you the right to produce it, and then all of a sudden there's this apparent monster out there going la pocketa, drilling a hole in the ground. There are lights going 24 hours a day, and there are roads cut across the property. Is that okay? Can they just go in and drill anywhere they want to and put any equipment in there they need to?
Well, again, it's easier to answer that question if we start with the idea of the gas owner also owning the surface, and then we'll maybe split out and say what happens if the surface and the gas are owned differently, because I think that changes the relationship a little bit. If the person who owns the gas also owns the surface, then probably the main way that the right to use the surface is going to be defined is going to be in the lease itself. Leases historically said that drillers would have the right to do anything that was, quote, reasonable and necessary to get the gas out of there, which would mean that if someone complained about the driller's activity and went to court, the way that the court would say that you should judge the driller's activity was, well, did it seem reasonable, and was it reasonable? Did it seem like all the other drillers would do the same thing? And could the driller show that it was necessary? You know, we have to do this to get the gas out.
They have to have a road to get there.
And
to haul
if you could
things in and
convince a
out.
jury that that was both reasonable and necessary, then the driller wins, and there's no damage, no compensation for whatever was done to the surface. Now, over time, because of the separation of the surface so often from the minerals, you would have surface owners saying, I'm getting nothing out of this. I get no money. And so the legislature instituted a statute that said that instead the relationship should be viewed in terms of if the driller does damage to the surface, that there should be requirements to reclaim the surface. And so as part of the permit process, there is an inspection by someone from the division or the Department of Environmental Protection to make sure that the land is reclaimed. And that some compensation is paid to the surface owner for the land that's affected by roads or by the well site, or if timber is cut or things like that.
What happens if the minerals and the surface are owned by two different people?
Well, then the gas owner is going to have some rights to say that, well, I give permission to this driller to come on your surface to drill, and the law historically has said that the mineral owner has that right. that the surface is subject to the mineral owner's desires.
The deed separating the surface and the minerals usually say that.
Right. And then the surface owner is going to be basically any right that the surface owner is going to have is going to be governed by this by the statute.
Yeah, they are entitled to compensation for damages, for example, to crops, fences, the road, the surface itself. And that is the surface owner's right. So they aren't just left out in the cold.
Andy Graham, Ken Tawney, thank you guys for being with us. Probably the best advice we can leave you with is if somebody offers you an oil and gas lease, or you hear there's going to be oil and gas drilling on your property, you might want to talk to somebody with some legal experience in that area. I would suggest an attorney, just off the top of my head. Thank you guys for being with us. Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. On the Law Works webpage at thelawworks.org, you'll find a listing of recent The Law Works program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the Law Works website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.